Welcome back to All Angles. Now, Kelly Khumalo's sister Zandile has taken the stand in the Senzo Meyiwa murder trial. All 5 suspects in the trial, or the new trial rather, have pleaded not guilty. Now, Khumalo has been describing the events leading up to the soccer star's death. Let's get more analysis on this from our legal expert, Marius du Toit. Mr. du Toit, thank you so much for joining us this afternoon. Of course, you've been watching with a close eye. What did you make of the court proceedings thus far?
Well, I think, firstly, we have to say that we are happy that the proceedings have started. I think the biggest difficulty was the fact that it was stop-start up to now. And at least the preliminary events have been concluded, the pleas were recorded, the necessary admissions were made. So now the evidence can start, and the evidence that has been adduced thus far is not of a startling nature. It's basically just setting the scene of the day in question when it occurred, keeping in mind that we have a different judge, so we have to adduce the evidence as though he has not heard anything. So the state would have to lead the evidence in the same way they would have done as though this trial has just started. And I think that's what we have at this stage, is the stage just basically setting the scene of the events prior to Senzo being killed.
Now, I know there's been a lot of talk about, this court case starting anew. And then, of course, there's the big question, is this an advantage or disadvantage for the state? Just your opinion again on that.
Yeah, so I think firstly we have to say that a de novo trial is never a nice thing, because basically the accused now have to start the trial afresh. If they wanted to privately instruct an attorney, their funds would probably run out. We heard in this instance that they're all making use of legal aid. Previously, there were private attorneys to an extent. So obviously, this indicates to you that they have been prejudiced to some degree to the fact that they weren't able to instruct their private attorneys. Having said that, it's also prejudicial to the state, because their witnesses are now being cross-examined afresh. Remember, these witnesses in many respects have already testified. Now there's a second bite at the proverbial cherry. And what we have now is that the new attorneys or advocates representing the accused can now cross-examine them again, but with the benefit of hindsight, of course, having the transcript from the previous proceedings. So they can now confront the witness with what the witness testified previously. So it puts enormous pressure on a witness to testify and to know that you're going to be confronted with what you testified previously. Now, I mean, you and I would expect the witness to stick to his story, but sometimes it's a minute difference in your testimony that could result in you being comprehensively cross-examined on that thing. So it's never ideal. It's prejudicial for the state, the defense, everybody. But I mean, it is what it is, and this matter has to be dealt with in this way. And at least the court has taken complete control of the proceedings and say we are now proceeding, which is a real positive.
Let's talk more about, Judge Mogoatleng. Is it normal for a judge to come out of retirement and then to take on a case like this?
Well, you must firstly remember that it often happens that judges are called back to do commissions of inquiries. I mean, in some instances we've had, I think, spring to mind the Sariki inquiry, which was a retired judge. So often you would find that the judge president in a certain division would call upon previous judges who have retired to call upon them to come and assist. And now we know that at the best of times, there's always a shortage of judges. So if you can call upon a retired judge, a seasoned, experienced judge to take over proceedings, that would stand in good stead the whole way in which the matter will be dealt with. Instead of pulling in a judge who's an acting judge, who's just started, who's perhaps trying to feel his way, we have a judge that's done this 100 times. He knows the race and he knows what to do to get the matter to proceed. So I don't think there's anything untoward about it. I actually welcome the fact that we now have a dedicated judge who has come in to take over this matter, and it's a retired judge. So he's not really involved in other matters, so that's really good.
And when we talk about bail, the bail application for the accused, I know that they will be, or they can come into consideration for bail at this point because, it is a new trial. But from my understanding, they will need to appear before a different judge than Judge Mogoatleng?
Yeah, so firstly, we have to say that all bail applications that have been dealt with thus far have been concluded, and those rulings will stand. So they've been denied bail previously, and we understand that there was a delay in initially obtaining a bail judgment in one of the accused with a previous judge. So when a bail application is considered, you would normally present evidence and you would have to prove new facts upon which this court has to consider and then consider granting you bail. So it would be ideally suited to have a new judge consider this separate from the matter. If, however, during the course of the proceeding, you want to bring an application based on the evidence which has been tendered, well, then, of course, you can approach the presiding officer, who is the judge at that time. But if, however, you want to deal with historical arguments, you want to deal with the delay in the proceedings, I think that's best suited if it's dealt with by a different judge. And normally what you would find is that the magistrate or judge who does the bail application, and normally, let me just say, bail applications are normally done in the lower courts. It's normally done in the regional or district courts. It's not normally done in the high courts. So if you have a situation like this where there's an application for bail, typically you would want a new judge to consider that so that it does not affect these proceedings. So it can run peripheral to the trial, and should that judge find on the balance of probabilities that bail should be granted and that you've proven new facts, well, then bail should be granted. If you are unable to prove new facts, so that judge will, of course, have sight of what the previous rulings were. The court would maybe have sight of the judgments that were previously given in order to consider whether this does, in fact, amount to new facts. But just the fact that these proceedings have been delayed tremendously in itself constitutes new facts. Whether that's sufficient to just say you should be granted bail is, of course, a different story. And that judge would have to consider it based on the evidence presented at that time.
And then, of course, are lawyers allowed to refer to the old case when it comes to, asking various questions? Are they allowed to point back to the old case in this regard, or is that not allowed in this court?
Okay, so when any trial is considered, it's considered on the evidence which has been adduced. If evidence was properly placed before a judge and the court made a ruling, of course you can't say, well, listen, your predecessor made a ruling and you're bound by it. That would not be correct. But what you can do is you can say, listen, I've got a transcript from the previous proceedings. And these transcripts of the evidence which was adduced is admissible in terms of Section 235 of the Criminal Procedure Act, which means that by mere production in court and showing that they've got a transcriber certificate, they would be admissible in the proceeding. So without a doubt, that's an important tool in the armory of the defense to cross-examine a witness and say, well, I'm referring now to the evidence that was adduced. Even if the state adduces evidence contradictory to the evidence that was adduced previously, there's nothing that precludes you from referring to the transcript and saying to the judge, well, this evidence, or confronting the witness with the discrepancy between his evidence and that which was previously tendered. So it's definitely an important factor to be considered by the defense. And similarly, it also helps the state, because remember, if I made statements to a witness, let's assume I put myself on the crime scene and I say, listen, I was there on the day, but I did nothing. And now suddenly the new attorney makes a statement to a witness and says to a witness, yes, I was not there, I was in fact at home. That would be completely contradictory to the previous statement. And once I get into the witness box, the state would be absolutely within their right, and they should, to confront me with the discrepancies between my two different statements made by my two different attorneys. So because you should expect, if a person tells the truth, his story should stay consistent in all material respects. And if I deviate from that, then of course that is subject to cross-examination. So absolutely, it's an important aspect. It should be considered, and I'm quite sure it will be referenced throughout this trial.
That's exactly what will be making this trial very interesting at the end of the day. Thank you so much. That was our legal expert, Marius du Toit, speaking to us on the Senzo Meyiwa murder trial.